Hi guys, it's Kathy. I hope you're doing well. We made it to Wednesday. Wow, it is Wednesday. Holy sheesh. We made it to Wednesday. We're almost at the weekend, guys. Just a couple more days. Hang in there. All right. So today we have California, I don't know, and Colorado. And I don't know, but you guys will. I think it's Florida. I could be wrong. Hold on. I have to know now. So you guys have to tell me. Where is this court right here?
The cash alternative would be fine.
Okay, essentially total $1,000 bond, $100 cash.
Yes, yeah, I guess that's true. Yeah.
Okay. Mr. Lockhart, does defense wish to be heard?
And Your Honor, we're just asking for a PO release today. Mr. Lorenz does not have any ability to post bail. He's never been employed, so he is not on Social Security. He's only on the temporary, effectively with EBT at this time. So has no ability to post bail, and we're just asking for that PO release. But we would ask to be appointed on this matter.
The cash alternative would be fine.
Okay, essentially total $1,000 bond, $100 cash.
Yes, yeah, I guess that's true. Yeah.
Okay. Mr. Lockhart, does defense wish to be heard?
Good way to do this. We're okay with that. Yes, sir. Thank you.
If you watched the video I put out yesterday, this is not the same case. It's a different case. Don't worry. But equally, the guy gets equally as mad. Very angry about child support. Here we go.
Okay. Thank you. Live 8, please, Your Honor. Ms. Harris. You were hoping you were next, right? Yeah, that's. We do like to give people some credit about coming to court, but we do interpreters first because we do need them in multiple courtrooms. Lawyers second because they're expensive. Mm-hmm. Easy cases third, and then people who were here. Actually, they're all easy, right?
Yeah, that's pretty quick.
Can you hear me now? I don't know why I need to turn my mic up. I don't know why. What's different from yesterday? But is this better? Okay, there we go. So we're in California, and then we're going to go to Washington, and then we're going to go to Colorado. We're just staying way over there today.
Yeah. I've only got 3 other people.
Yes.
On 2 different cases to finish out my calendar.
That's nice.
That's what I'm saying. Okay, so Mr. Blunt, are you going to turn your video on or just going to sit there and watch us?
Oh yeah, I'm trying to figure out how to turn.
Let me help you.
How's that? Is that better? Now are we even? I don't understand the question, Kelly. How did we do on Twitch? I don't understand the question.
I'm going to give you a prompt. You just go mute yourself. That's not helpful. Okay, there's the prompt for that, and there's the prompt for video.
Okay.
See how easy that was?
There we go.
All right, so we're here for a modification and credits.
Numbers for what? Tell me what
I'm
numbers
sorry.
and I'll go
Wrong.
get them.
Just a modification. This is filed at mother's request.
Subs? I don't know. Like 4, 6
And
bits?
oh, sorry.
I don't know how many bits. I would guess.
DCSS says you have 2 children
200?
together.
200?
Last case, the timeshare was 2%. This time it's 22%. Does that sound right?
700,000.
Yeah.
Sir?
I believe so.
Yes. We have view. Yes. I'm an affiliate now. I
That
got
sounded like
4
a
days.
whatever answer.
So we're good.
Because the time varies. Sometimes I get them before I'm supposed to get them.
I mean, that's up to him. But in the order, it changed because he has them every 1st, 2nd, 4th, and 5th weekend from 8 a.m. p.m. Saturday. 8 a.m. Saturday until he dropped him off at school on Monday. And in the court order, it says unless they're not in school, then we figure out a time for him to drop them off. And on the third weekend, I dropped them off at 6 p.m. on Saturday, and then he drops them off to school at 8 a.m. if they're in school.
Okay.
No, you don't have to go to Twitch, but if you want to watch the live stream with no ads and you have an Amazon Prime account, you get a free subscription to a Twitch channel with that. You can use that on Twitch to watch this live stream that you're seeing right now with no ads.
Get that to be 27%.
And I've been trying to get 50-50 joint custody for the longest, but they never.
Can you take the toothpick up, please?
I said that I've been trying to get 50-50 joint custody, but every time I go to court, they never give me what I'm asking for.
That's probably because she didn't say sure, why not?
Does he want
So are either of you
50-50?
married?
No,
Does he want 50-50? Or does he want to not pay support?
we weren't.
Not to each other,
Oh, no.
to anybody.
I'm not.
No.
Sir, you have other children that you pay support for?
Yes.
Look like you work for the government too.
Yes.
The state?
Yes. I work for the city and county of San Francisco.
Oh, that's not the state. That's the city and county of San Francisco.
Yeah.
It says you make $8,376 gross per month. You do health insurance premiums and retirement. You got a paycheck?
Yes, we had a
Okay. And ma'am, it says that you make $3,638 gross.
I don't know how I make that much.
We used EDD first quarter of 2025. It appears
What you averaged in the first 3 months of this year.
Nothing. I haven't received EDD this year at all.
No, EDD is where your employer reports what
Oh,
your income is. When they take your taxes out,
mhm.
they pay it to EDD.
Right.
EDD forwards that on to the Internal Revenue Service and franchise tax. They're just the central.
Is it 3,000 including the child support, or is it just
No.
employment?
No. That's your income before they take out any taxes.
correct. And there are multiple employers here, and we put them all together and average that.
Yeah. So is it Amazon on there? Because I'm no longer working with Amazon.
No doubt.
I'd have to go through it and sort that out because there's multiple employers.
Or are you working fewer hours or no hours with Amazon because you're working more hours with the others?
Amazon was only a temporary assignment.
Oh, like for the holidays?
Yeah. So it's over now.
Well, for now. The holidays will come back and they'll want you back.
Yeah, if I reapply, but
Very soon. Very, very soon. It's already August, guys.
Click on there.
Well, let me tell you the important thing and see if it makes a difference. With all of that, the amount of child support is $1,208 a month.
mhm.
Is that satisfactory?
I mean, that's fine. I'm not trying to make the man work harder and he take care.
I'm not able to afford that.
What can you afford?
I can barely afford the $790 now, so they're trying to almost double it. I still have bills. I have other kids. I'm traveling up and down the road. I have to pay for food. I have to buy the clothes for my kids when I have them. She's not sending me with nothing. I'm providing them with everything.
Am I supposed to? He wants 50-50, but he's complaining about what he's doing for them.
I'm not complaining.
Oh, he's talking about the other kids.
The other kid.
I'm not complaining about anything. I'm just saying that I'm not able to afford that. If I was to give you $1,200 a month, that means I would only have one check for myself. I only get paid 2 times a month.
Maybe, sir. Maybe, sir. But the fact is, children are expensive. And you are paying $790 a month right now for these children. I don't know how many there are, so I'm just going to go with 2 to give you the benefit of the doubt. Children cost more than 300 some dollars. They just do. They cost way more than that. So even if you double that, she does 300 some, you do 300 some. That's not enough. That is not enough to raise a child. He makes $8,000 a month. I just don't get where all the anger comes from, because they, like, if you don't have the child 50-50, if you don't at least have the child 50-50, they're doing all of the work. It's so much. Even one child is so much work. Multiple children are, and it's every day, and it's just food alone, shopping and cooking and then cleaning. No, it's not enough. You're mad. You're mad that you have to pay this, but what comes out of her pocket is way more than that. Every dime she has in her pocket goes to the kids. Your dimes go wherever you want them to go, except for what the court makes you give to her.
Your Honor, the children.
I'm going to get some comments for that, because usually when I play child custody cases, I get all kinds of comments about how the women are out to get these men. They're out to get them, take them for every penny they have. No, children are freaking expensive.
Not receiving K-1.
It say that I make 8,000, but after taxes and all that, I don't even bring half of that home.
Well, you've got more than just taxes. You've got
Exactly. I got taxes. I got child support getting taken out. I'm paying for their medical.
right, and union dues and
Union dues.
mandatory retirement. I don't have any pay stubs though, so I can't see any of that. Is there a number you're willing to accept?
I can do 1,000 a month. I mean, he helps me with nothing. They go to school 4 days out of the week from my house.
Just needed the 1,000.
Okay.
I can't do 1,000.
Yeah.
Well, she believes that's what she needs to help take care of these kids. I'm willing to do that as a deviation from guideline.
I can do 900. I can't do 1,000. Like, my rent is $3,500 a month. I have other kids as well.
You don't need to live somewhere that's $3,500 a month. You just don't. You have kids. I couldn't live where I wanted to live because I had kids and I had to pay for them.
I still have to maintain some type of living as well. It's not just about what she wants. Every time I come to court, it's about what she wants and what she says.
See?
It's like I have no
No, it's not, asshole. It's the children. The children need money to live.
say so on anything.
Wait. You have to understand the initial number we came up with, the 1,208, that came right out of your pay stubs. That's not about who asked. She asked for a change. She says she needs more money to help take care of these kids.
I know, but I'm not seeing how they get $1,200 out of my pay stubs. That's more than half of my check. If I'm paying, than one of my checks. If I'm getting paid twice a month, right? That's like I'm giving her one check every month.
How long have you worked there? You get paid every 2 weeks, by the way.
Exactly.
Well, so that means that twice a year you will get a third check that you won't get any of. Although what's really happening is she gets the same amount out of each and every check.
Exactly. So she's getting money out of each check. So it's not, listen, I pay so much child support that it's already paid in advance. Any kind of money I get, they got their hands in it. So I would prefer.
You worked there since 2019, yeah?
Yeah. And
Okay. Hold on, I have a specific question. You filed your taxes for 2024?
Thank
No,
you.
because
Thank you. Thank you.
she
Thank
told me
you.
that I was gonna be able to file my son, and then she ended up filing him, so I wasn't able to file.
Well, it doesn't mean you can't file. It just means you can't claim the child.
No, I didn't file because she told me that I could claim him, and when I tried to do it, she already did it.
Did you file a return for 2023?
Yes.
How much was your refund?
I didn't get it. She got all that money. They
How
took
much?
everything.
How much
How
was
much
the
was it?
refund that she got?
I believe it was like 5,000.
About 5,000?
Yeah.
Okay. Well, so that's the reason that was available is because the city and county of San Francisco is taking too much money out of your paycheck. So that's what you need to change is how much they're withholding. You can change your W-4 to have them take less money out of your paycheck. According to this calculation, if we're going to be 1208, you would have about $3,400 a month to pay for your personal expenses. Your INE that you file, the income and expense declaration, says your rent's $2,750. But even if
No, that's the old one. That's the old one. That's the old. You have all old things. You have all old things.
I get it.
So on purpose, he moved into a place that was $1,000 more a month.
Oh.
It's a year and a half old, but it's the only one I have. And even with that, if all you have left is 3,400, that's not enough to pay for the rest of your expenses. I get that.
Exactly. That's what I'm saying. So how can I maintain my living? And I still have other kids.
Yeah, I understand. That's been taken into consideration, by the way.
I don't think so.
Yes. He
Yeah.
just did 700 on his income and expense declaration. We
Yep.
gave him credit without any documentation, actually.
Oh, it's not being paid through CCSS?
No.
Okay.
He's not paying
I
for
would
that
prefer to
kid.
pay her directly if I could, but
Not at all.
No, she doesn't want it. It's her call.
everything she getting is tax free, man. They taking it out before anything. So
The child support is tax free. The cash aid she's getting is tax free. And the wages that she's getting is not tax free. So are you willing to accept 900?
No, I can do 1,000.
Okay.
I can't do 1,000.
So it doesn't
I
matter.
can barely do the
Dover.
790
He's going to make it 1,000 because that's the law.
right now.
Yes.
Like you sitting there telling, you just told me that what they taking out, I still won't have enough money to maintain my bills though. And what I need to do to survive. If I'm not right, the kids won't get nothing.
I'm
And
in a
then,
household and I pay all the bills by myself. He's in a 2-person household, so he should be able to
and
make.
then,
Oh,
and
he
then on top of that,
It's just him. And
No, he lives with his child's mother, and she receives aid for her child as well. And
then listen, and then on top of that,
and they
they're
both
going to be cutting my hours.
child does he can't afford it.
They're going to be cutting my hours at work.
Well, bring some pay stubs in when that happens.
They got the pay stubs. I submitted them.
Not the ones with the hours reduced.
They have them. Yes, they do.
Oh, what I heard you say was that prospectively they're going to reduce your hours.
They already have.
Well, that just means that her agreement to 1,000 takes into account that your hours have been reduced. So I'm going to make it 1,000 starting July 1. All right, you'll both get a copy of the order.
Okay, thank you guys.
All right, bye-bye. Good luck.
Hopefully after I finish nursing school, I won't have to see you guys again because I'm not taking them off everything. You guys have a good day.
Six.
Number 6.
That poor guy. I wonder if the next guy's going to be angry. The last guy I showed in my video swore at the judge and screamed at the judge. But it turned out all right.
Oh, good. I was getting a little concerned that when I said the calculation said 1208, that I hadn't changed. I had.
The funny thing is, I was also concerned for a second because if we used his, the amount that he listed on his INE, it would have been 1280 a month. So I was like, hold on, no, so weird.
What?
Yeah, with the 22%, if we used a little different income.
Oh, okay.
That's not bad.
Hello, Ms. Orr.
Hi.
That's line 9, that's 6.
Yeah, almost. Got one more before you, sorry.
Okay.
But I do have Ms. O'Connor.
Yeah.
And Mr. Ford, who's going to unmute his device.
Yes.
So we're here for a modification. You have custody now, sir?
Yes, I do. I've had him since September 23rd.
We
Is
love
that
to
right?
hear
That's
it.
incorrect. No, there is no
Oh.
custody agreement. There was a case that resulted in him having them, but that we've never
Okay.
gone to court regarding custody as yet. And it was
I love that he has the kids. I love that.
2024 in September when he received them.
Okay. And has he had them since September of 2024?
Yes, he has had them since then. Yes,
Have they spent any time with you since then?
he has refused to let me see them up until a couple days ago, but I had to work. And I explained that to him, but since September 2024, he has not let me see them at all.
But
He
I
won't
have
even
to
let me
work.
talk to them.
That's what she said. But I have to work. I can't see my kids. I have to work. Good job, Dad. Good job.
Mr. Ford, are you asking for support from her or just
Yes,
wanting to
please.
zero out your order?
Ask for support.
Um,
For support. Get support.
yes, I would like support
Yes.
while they're in my custody. Yes.
I can tell you I have no income and expense information for either one of you, so I'm not in a position to do anything about that today.
What we did regarding the income figures is we happened to find the work number reports all the way through July for both parties somewhere.
How did you do that?
Magic. We probably got it from the DHA database, my understanding.
But it also doesn't give us deductions.
Of course, that's just giving that.
So, but I can zero out your order to pay support.
Okay.
I'm sure that will make you happy.
Yes.
That will be effective July 1. I'll give you credits. And that will be above any payments. To the extent it doesn't create an overpayment. And that will be for October of 2024 through June of 2025. Are there still going to be arrears?
Yes.
A lot.
Yes. He is in arrears about 45,000.
Is support assigned?
Support. Part of it is, even though mom didn't have the children, she was still receiving CalWorks for the children, so she's going to get off aid. But
$45,000 in arrears?
part of the support is assigned. She's off aid now, so technically it's not assigned.
Okay.
But some of the arrears is permanently assigned.
You mean the part that's when it's paid, it's going to go to mom?
Yeah.
Yeah.
But we still have to collect it.
Right.
Yeah.
So, Mr. Ford, if you want support from her, I'm going to need to continue this to another date. Require both of you to file income and expense declarations. Obviously, if either or both of you don't, then we may just have to go with the information that Mr. Asred got from a database. But what I would prefer is the income and expense because that'll give me some deductions that the database doesn't provide us with.
Michael.
Yes.
Do you want to come back or no?
Yes. I would like to make another date.
Is there another date for a custody hearing currently?
No, I'm working on that. I'm filing paperwork tomorrow for that.
Okay. What I would suggest that you do when you file that paperwork, check the box to modify child support. That way,
Okay.
I'm going to do a date today, but if you check the box for child support, then we'll be able to have the hearing for custody and support on the same day rather than two different.
Okay.
You have to come back. And then we can vacate the other date.
Okay, perfect.
So September 29th.
Yes.
No, my clerk says no. He has the right of first refusal.
I actually had a question, Your Honor. How would I go about, because all that child support, the $45,000 is back from 2018 when me and her were married and together in the house together.
We were not married for that long.
Were you living in the house together?
He was living there, but he got kicked out because he cheated on me with POF. And so he left the household. And we haven't been together since then.
Okay, so the way you deal with that is if that's an aid time, then you can file an application for the debt.
He's been denied already. He applied in 2024 and it was denied.
Oh, it was?
Yeah.
Okay, well, I assume you brought up all those issues when you applied for debt reduction earlier.
Yes, I did.
Okay. Okay. So October 6th, you said? Yep. October 6th, 1:00 in the afternoon. I will need both of you to file income and expense declarations by September the 26th.
Okay.
All right. I don't see that there's an arrears payment. Do you have an arrears payment? At this point, I don't want to make it a lot.
Well, I mean, we're coming back in September, so we can just set it then. See how much credit he gets and everything.
How much credit?
I mean, we're giving him credit for the times that he had the custody of the children, right?
Oh, actually, I already did that for October through June. I guess you need to put that in.
Yeah,
your
exactly.
system
That
to
needs to
find
be
out what-
processed so we can have an
Yeah.
updated figure.
Yeah. All right. We will see you back here then.
Okay, thank you.
Bye-bye.
Thank you.
Bye.
This is where I told you it wouldn't be
One
long.
more.
Yeah, you're right about that one.
Oh, now she's
One more.
ignoring me. And she's making me pay for teasing her. Oh,
There we go.
So in your case, we're here for a judgment. There's a voluntary declaration of paternity. Head of staff, Mr. Alexander is the father. I'll join you as the other parent to this case and enter the judgment.
Mhm.
Mr. Asred?
Support is assigned in this case. We did impute, we have two calculations for you. I believe one of them imputes part-time minimum wage.
Do you have any income other than Cash Aid and CalFresh currently?
I'm starting work. I haven't even started training yet. I'm still waiting for my background and whatnot to go through.
Does Mr. Alexander have any parenting time with these children or with
No.
his child?
No.
Okay. Do you know whether he works?
Yes, I know he has his own business. He's a tattoo artist.
Oh, one of those.
Yeah.
No, I've actually several tattoo artists who come in here and cry poor mouth. No, I make no money. No, it's because you got all that art all over your body.
Yeah, and for me, there's no way for me to actually prove how much he makes, so I can only go based off of what he tells you guys.
Well, what does he tell you? When you were,
Nothing.
was he helping bills?
No, not at all.
Which is-
When the first maybe 2 months of Dream being born, he did help. But since she was like 2 months old, no, nothing.
Well, how long were you together before she was born?
We were never together.
Ah,
Yeah,
well, for 5 minutes, maybe.
literally. Yeah.
Okay, so
That's unfortunate.
what's the net and the amount of the support for halftime?
Halftime, the support is going to be $393 per month, and the net is going to be. Wait a minute. This is not halftime. This is full time. Sorry, I need to fix this. All right. So for part-time minimum wage, the support is going to be $108. So no income adjustment. The net disposable is going to be $13.09.
All right. And that's starting 9/1, 0 for June through August.
I did
Health and reporting for the father only. That is your judgment. You are good to go. Oh,
Okay.
13.
I'm not sure what's going on. Here we go. Okay.
Still don't want to talk to him.
So we're all done here.
We are all done here. You can go away completely now.
Perfect. You guys have a good rest of your day. Bye-bye.
We're going to listen to him say goodbye to everybody, okay? We're just going to wait another
What's
minute.
up?
All right. Number 7. I was hoping just a second. Let me save this and get out of here.
Are you mumbling over there?
Yes, I said, let me just save this and get out of here. So that's opening number 7. Support is assigned on number 7. We are asking that part-time minimum wage be imputed on that. Or mom, actually. Mom is the non-custodial party. Grandma is receiving aid with one of the children in Sacramento Catholics. The other child gets SSI.
Oh, that means one of
Zero
the parents.
parenting time.
0 parenting time.
Oh. So there is an existing order.
There is an existing order for $114 a month. And if we do part-time minimum wage, it goes up to $173.
Yeah, well, that's what you're asking.
Yes.
Yeah.
All right. The net disposable is going to be $13.09.
So that's
starting 9/1.
the other girl got 170
Everything else
some a
stays the
month.
same. Pack the foods are after the calendar. Sherry's just getting back from lunch.
Say goodbye to us, Judge, so we can. I'm going to bump it forward.
Assuming they're not watching.
Somebody's watching.
Anybody else from fan club is watching? Not calling anybody out at DCSS. I'm assuming they're not watching.
Somebody's watching. They told me they're watching.
Okay, taking a risk.
Big time.
See everybody tomorrow morning at
Bye, Judge. He is an amateur when it comes to pondering. That is a fact. All right, Washington or Colorado? Colorado.
Show up. She's pretty disheveled.
Hold on.
And
I'm going to go back just a little bit. This is a new judge to us, Judge Jill. How far forward did I go? Okay. They left.
Gibson. This is 25M18 out of Rangeley. Hello, Mr. Gibson.
Hello.
Ms. Miller, what would you like to tell me on his behalf?
And Judge, I have to advise the court that I have a conflict with Mr. Gibson's case, so the court will need to advise him. I'm sure he still wishes to address bond with you.
Thank you. Right, Mr. Gibson, I will start by advising you on the arrest charges. Looks like you were arrested on 4 charges. The first is assault in the 3rd degree, which is a Class 1 misdemeanor. The penalties for a Class 1 misdemeanor are up to 364 days in jail and/or a maximum fine of $1,000. The second charge is reckless endangerment. That's a Class 2 misdemeanor. The potential penalties for a Class 2 misdemeanor are up to 120 days in jail and/or a maximum fine of $750. The third charge is theft, which is also a Class 2 misdemeanor with up to penalties of up to 120 days in jail and/or fines of $750. And
I hope you're right, but I don't think so. I've not yet seen anybody else start playing Colorado. I wish they would. There are so many good judges in Colorado. I wish all the other content creators would go get Colorado. But I've not seen any play Colorado yet.
And then the fourth charge is crime of violation of a protection order. That's a Class 1 misdemeanor. The penalties for a Class 1 misdemeanor are up to 364 days in jail and/or a maximum fine of $1,000. The purpose of the hearing today is to set your bond and to enter any protection order that is necessary and to set a court date for you to appear in front of Judge Edwards, who is the judge assigned to your case. Let me hear from Mr. Lund about the people's position on bond, and then I'll come back to you. Okay, Mr. Gibson?
Okay. Your Honor, the people are asking for a $5,000 cash or surety bond in this case. The allegations involve ones of domestic violence. The defendant has a prior domestic violence case involving the same victim that's from March of this year, which also formed the basis of the protection order violation in this case. The victim's input in this case is that she does want the defendant to receive a PR bond, and she does want to have electronic and in-person contact with the defendant. The people are asking the court to enter a full protection order today, including
Judge Khan YouTubes. That's why I love Judge Khan.
prohibiting contact between these two individuals. Quite frankly, the victim in this case was lucky she wasn't more severely injured. The allegations include her being drugged outside of a moving car. When deputies show up, she's pretty disheveled, and people feel like the defendant is unable to follow the court order, specifically the protection order that was entered in the previous DV case. And so that's the people's request today. Thank you.
Thank you. Mr. Gibson, what would you like to tell me about bond and the terms of the protection order that I'm going to enter?
I would like the PR bond if at all possible. I have work that I need to get to. And the protection order, I think the allegations are not, I don't know what to say.
I don't think you should speak to the underlying allegations or what happened, but just in terms of the protection order, are you able to abide by a full protection order?
Yes, Your Honor. I can abide by partial protection order, full protection order, whatever you need.
Right, you don't live with Miss Bassinger?
No,
Okay, you don't have any belongings at her home?
no.
Okay. And I didn't get a CPAT for him. Did you?
I did not, Your Honor. I can recount some relevant criminal history, but I have no understanding of his failure to appear history or anything like that.
I did come all the way
What-
from Oregon to take care of this. My mom just passed away, so that's the reason why I had left in the first place, was to deal with her final days and the funeral arrangements and stuff.
Okay. So did you turn yourself in on this warrant?
Yes, I did.
All right. I will authorize your release on a $1,000 personal recognizance bond.
Thank you.
However, as a condition of that bond, I'm going to enter a mandatory protection order. I'm going to review the terms of that order with you and ask that you acknowledge them on the record, okay?
Yes, Your Honor.
All right. The protected party is Kaylee Bassinger, and it's ordered that you not harass, molest, intimidate, retaliate against, or tamper with any witness to or victim of the acts that you're charged with committing. You must
Hey,
vacate the
Sherry.
home of the victim,
Hi.
stay away from the home of the victim, and stay away from any other location she's likely to be found. You must refrain from contacting or directly or indirectly communicating with her. You shall not possess, purchase, or control a firearm or other weapon or any ammunition. You must relinquish any firearm or ammunition in your immediate possession or control within 24 hours of your release from custody. You must complete an affidavit and file it along with proof of relinquishment with the court within 7 business days, and you shall not possess or consume alcoholic beverages or controlled substances. Do you understand the terms of that
Yes, Your
order,
Honor.
sir?
Yes, Your Honor.
And please understand that violation of the protection order is punishable as a separate crime and as contempt of court. So it's important that you just stay away from Ms. Bassinger while this protection order is in effect, okay?
Your Honor.
Do you live in the Rangeley area, or do you live in
Yeah.
Ohio?
No, I don't live in Ohio. I don't know where that
Okay.
is. I live in Rangeley.
Okay. All right, then let's set a court date for you to appear in front of Judge Edwards there. All right, it looks like you have another court date already set for September 3rd at 10 a.m.
Yep.
How about if we just set this at the same time?
That works.
All right, please be sure to appear on that day, okay?
Yes, Your Honor.
Thank you.
Thank you.
Take care. All right, now we can go to Garfield County. Oh, it looks like we also have Pitkin County on. We do have Miss LaRoche, the Spanish interpreter, so perhaps we should go to Mr. Samuel Medrano Vasquez, 25N360.
Right.
Is it Medrano Vasquez or Medrano Antonio? In the file, it says Medrano Antonio. Hello, sir. Can you tell me what your name is?
Samuel Antonio Medrano Vázquez.
Medrano, ¿qué, perdón?
Vázquez.
Samuel Antonio Medrano Vázquez.
Okay, thank you. Good afternoon. Ms. Miller, what would you like to tell me on Mr. Medrano Vasquez's behalf?
Hold on, Your Honor, I got disconnected for some reason.
Accepted from ECF sometimes.
Let's try that again.
We're connected.
Thank you. All right, Ms. Miller, what would you like to tell me on his behalf? Oh, hold on, you're muted. Let me unmute you. There you go. Nope.
And the judge be right, one of us. Stop.
Oh, you're the number ending in, okay. Try that.
Okay, Judge, can the court hear me now?
Yes, thank you.
Sorry about that. New computer's audio is being difficult. Judge, for Mr. Madrono Vasquez, the court can see in his CPAT that he does have pretty minimal criminal history. He has a 2020 driving under the influence conviction and a 2021 Class B traffic infraction. Aside from that, he does not have other history. According to his CPAT, I'll also note that in the last year, he has 0 failures to appear. In his lifetime, he does have 2, but one of those is from over a decade ago in 2014. He did note that he understands that if a protection order is put in place, he will have to stay away from the alleged victim and anywhere that she may be found. I did ask him if he would have somewhere else that he could go. And he did say if the court requires it of him, he will stay away from where he was previously living. However, I think it should be noted that that is his residence. And if given the opportunity, he would like to return there. He noted that while he does not have family or people in the community that he might be able to live with, his girlfriend and her daughter, the daughter being the alleged victim, do have family that they may be able to stay with. Perhaps the state has input on that when we get there. But if he's required to, he will vacate the residence and live somewhere else while the court has a protection order in place. He did advise that he has been looking for work. He is a laborer. He does construction work, and he is actively looking for employment. He has been in Colorado for around 13 years. This is his home. He is not going anywhere. He did advise me that he will come back to court for this case. He said that he always comes to his court dates. He wants to take care of this. He understands that if he's released, he will need to fill out a public defender application if he wishes to have our assistance on the case. He does have the ability to get to and from court if he's required to be present in person. Further, he has a phone that he can call into court with if he's permitted to, and keep in contact with any attorney or anyone who is helping with his case. He also noted that he rents that place that where this case allegedly occurred at. That is somewhere that he has to pay rent on to make sure that roof is still over either his head or his girlfriend and her daughter's head, depending on who the court permits to stay there. He does have very minimal funds right now as he is currently looking for employment. That makes it a bit difficult for him to post any amount of bond. Because of that, I am asking that the court give him a personal recognizance bond in the amount of $1,500 and permit him to come back to court on his own promise. That is my request for the court today. Thank you.
Thank you. Mr. Lund?
Your Honor, the people have no opposition to a personal recognizance bond in Mr. Medrano Vasquez's case. Of note, we have been unable to contact the mother of these 2 victims, Miss Flor Garcia, so we are unable to provide input on their behalf today. Based on the allegations.
Yep, that's what I just said. Judge Khan. I forgot. Judge Khan does YouTube. He streams on YouTube. We love Judge Khan. We've been watching Judge Khan for many years here. Oh, Rollo the dog. Do you guys remember Judge Khan, Rollo the dog? Oh, that was so sad.
In this case, we are asking for entry of a protection order.
And then there's that other judge who streams in that courtroom that looks like it kind of looks like a big conference room with like the 12 chairs up front and the water thing, Edgewater decoration on the wall behind them. You know what I'm talking about? You guys know what I'm talking about. They come up to the podium in front of the big panel. I can't remember her name. I know. Oh, if I showed it, you guys would know it right away. But I can't remember her name. And there's one more on YouTube, I think. I think it's Colorado, with the blind prosecutor that we didn't know was blind for a year and a half of watching him because I mean, he did so well. He looked like he did not look like he was blind at all. He talked to the people. He helped them sit down. Da 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 da. I can't remember her name either. She's really good. No, I don't. Her name's nowhere near my brain. Just remember Judge Khan.
Protecting Fidel and Ruby. These are teenagers who felt threatened by Mr. Medrano Vasquez while he was holding a hammer. I understand there is maybe some issues with the residents, but to protect their safety, we are asking for that mandatory protection order to enter. We do not have an objection to resetting this case pretty quickly in order to obtain input on that protection order from Ms. Garcia. But at this time, in the interest of the public safety of these two children, we are asking for that protection order to enter. Thank you.
Thank you. All right, Mr. Medrano Vasquez, I will author.
Talking about Law Talk with Mike, I was going to play one of his clips today because it was really good. He streamed yesterday, but I didn't, and I'll tell you why. First, let me give you the link to this. To what I saw. So I was watching this one right here. Let me give you the link. It was really good. Hold on. And it was about this guy. Is it this guy? No, it's this guy right here. It's Judge Washington. This guy right here is such an asshole. He is such an asshole. Oh my God. I was so mad at him. And I thought the judge was ready to slap him down. I was waiting for it. And then she didn't. So just so you know, he takes no accountability. He blames her the entire time. And then he says, he says, I haven't drank in 20 years. And they're like, well, you just failed a drug test. We had alcohol in your system last week. And then he's like, I never hit her, never. And oh my gosh. So I was going to play it. It was so good. I enjoyed it so much. I was going to play it during my stream. But you guys, you won't enjoy the verdict. So I didn't. Instead, I'm playing Chill.
Authorize your release on a personal recognizance bond in the amount of $1,500. As a condition of that bond, I am going to enter a mandatory protection order. I'm going to review the terms of that order with you and ask that you acknowledge them on the record. The protected parties are Ruby Saldivar and Fidel Aram, and it's ordered that you not harass, molest, intimidate, retaliate against, or tamper with any witness to or victim of the acts that you're charged with committing. You must vacate the home of the victims, stay away from the home of the victims, and stay away from any other location the victims are likely to be found. You shall refrain from contacting or directly or indirectly communicating with the victims. You shall not possess, purchase, or control a firearm or other weapon or any ammunition. You must relinquish any firearm or ammunition in your immediate possession or control within 24 hours of your release from custody. You must complete an affidavit and file it along with proof of relinquishment with the court within 7 business days, and you shall not possess or consume alcoholic beverages or controlled substances. Do you understand the terms of that order, sir?
Sí.
Yes.
All right. Please understand that violation of the protection order is punishable as a separate crime and as contempt of court. This order does require you to stay away from the home where you were previously living. I will authorize a one-time civil standby with the Silt Police Department. You can contact the Silt Police Department to accompany you to the home to collect any non-contested belongings. We need to set a court date for you to appear in front of Judge Petotsky. How about, the calendar here. Do we want to do Monday, August 18th?
Works for the people.
Judge, is there any way we could do it sooner, just in case the state's able to get in touch with the alleged victims regarding this protection order? I don't know if maybe the 13th.
We could do it August 13th.
No objection.
Okay, August 13th at 8:30 a.m. with Judge Petotsky in Rifle. Thank you, sir.
Sí. Señora, pues quisiera hacer una pregunta, si me pueden cambiar las cortes a Glenwood Spring, ya que estaría viviendo en el área de Echeverry y me quedaría demasiado lejos, Rifle, Colorado.
Your Honor, I would like to know if the court could me move to Glenwood Springs, because I would be living in the area of Algebel and it will be too far away.
I cannot, because it's based on where the incident occurred, which is in the Rifle area. So it will be in front of Judge Petotsky. Do you know if Judge Petotsky allows WebEx?
I believe
He does,
Your
Judge.
Honor.
He does,
Your Honor.
All right, I'll authorize you to appear by WebEx if you need to on next Wednesday. After that, it will be up to Judge Petotsky.
Yes. Okay, thank you, Your Honor.
Thank you.
Yes.
And just to confirm, no one else requires the interpreter, correct?
That's correct.
All right, thank you, Ms. LaRoche. Ms. Miller, do you have a preference who we call next?
Judge, I can see Mr. Schaefer is on the line. I think that he is here for one of the Garfield County in custodies.
All right, Mr. Schaefer, who are you here for?
Good afternoon, Judge. Dylan Oliveira. He's Garfield County in custody.
All right, this
Your-
is 25
Your Honor, I
CR
have a
218.
request. Just because of the nature of the allegations in this particular case, I'm wondering if we would want to leave this towards the end of the advisement docket.
All right, do you mind waiting, Mr. Schaefer?
I don't. I'm waiting for a verdict, so if I don't appear immediately, I'm in the other room.
Okay.
Not guilty.
Thank you.
There you
Hopefully
go.
the timing will work out. We also have Ms. Mayton here. Who are you here for, Ms. Mayton?
Good morning or afternoon, Judge. I'm here for Nate Keene. He's in the Pickens County Jail.
All right. Do we want to call Nathan Keene's case?
I'm comfortable. Does Ms. Mayton represent Mr. Keene, or is she here to observe?
I'm here for this limited appearance. That's why I told the court we could call Mr. Keene.
Okay, I'm comfortable calling that case.
All right, this is Pitkin County Case 25 CR 33. Hello, Mr. Keene.
Hello.
And will the deputy there please confirm that Mr. Keene heard the general advisement?
Yes, Your Honor.
Okay, thank you. And Ms. Mayton, did you have an opportunity to advise Mr. Keene?
I have, Judge. We had some time for conversation, and we are prepared to request a bond.
Okay, please go ahead.
As you know, we were here last time with Ms. Layton, the co-defendant, and the judge set a $75,000 bond. We were recently in front of Judge Maker, and the judge set it to a $30,000 bond with a GPS locator. The reason I provide that information to the court is because, again, Mr. Keene is the co-defendant. Mr. Keene did turn himself in. He was not arrested.
Monica, thank you for the bits. Thank you, thank you, thank you.
While he was advised that there was a warrant and to turn himself in, he was trying to gather up some bond money. He was able to gather up some money to post a bond. He has $5,000 in cash that he could post, or a surety. Obviously, if he can post the cash, he'd like to get all the money back. Regardless, he is a trustee at the Eagles. He has lived in Aspen for the last 10 years. He has had several cases in the past, but he has never failed to appear. He is aware of the GPS monitoring request from Judge Maker and has no objection to that in order to ensure the safety of the community and his whereabouts, to help appease just Your Honor, the District Attorney's Office and the community. When he is out of custody, I know that he and the co-defendant will be figuring out their respective attorneys. One will be going with the public defender and one will be going with me. I just, at this moment, this is for this particular matter. So that is the request. Obviously, we know the seriousness of the allegations. Mr. Keene has also been living in the same residence for the last 2 years. He is stable and embedded in the community. So I would ask the court to consider either giving it the same consideration that Judge Maker did and provide a $30,000 cash or surety bond with a GPS monitoring system, or $5,000 cash only with a GPS monitoring system. That is our request today. Thank you.
Thank you. Mr. Lund?
Your Honor, I believe Miss Londo, the victim in this case, is on the line and would like to provide some input for the court.
Thank you. Ms. Londo, what would you like to tell me about bond and the terms of the protection order?
No matter what she says, it's going to be annoying. She's either going to say, oh, he didn't mean it. We were just playing around. The police got it all wrong, and which is annoying because that's not true. Or, no, the other one isn't annoying. Sorry. Or she's going to be like, yeah, he ruined my life. He needs to go to jail. I don't know which one it's going to be. Here we go.
That I'm going to enter.
Hi, Lisi. Lisi, what state do you live in?
I can hear you.
Okay. I'm not gonna answer that. I think because of the severity of this and what they did. Excuse me. No, absolutely. Given this past, there's been several violations of protection orders multiple times. They're both he's a threat to the general public.
I'm having a little bit of a hard time hearing you.
Judge, she said he has broken the protection order multiple times and he is a threat to the general public.
I don't know if there's any adjustment you can make on your end.
Understand her at all. I'm so sorry. And with all respect, I do want to hear what she has to say.
Ms. Londo, I'm sorry. Would you?
I'm sorry. This is really hard for me because of the severity of what he's done to me. I'm very emotional. I am fearful for my life right now. He's physically and mentally and emotionally destroyed me. I can't, it's been debilitating on my life. I can't go back to work right now. I'm a mess. I'm an absolute mess right now. He's also, there's been several times in his past he's violated protection orders. He's a threat to the general public. And like I said, given his past, he needs to stay locked away. Please, Your Honor.
Okay. What I did hear is that she's in fear of her life, physical, emotional, and mental safety, and she would like him to remain incarcerated. Mr. Lund?
I don't even think he blinked.
Your Honor, these people are asking for a $100,000 cash or surety bond. This case involved 2.5 days of physical and emotional abuse of Miss Londo in a doctor's appointment described in the affidavit in this case. Physicians assessed her with a broken orbital well, a jaw fracture, multiple rib fractures, and bacterial vaginosis, assumedly from trying to hide this spare truck key to escape in her genital area. This occurred for no clear reason. The defendant just decided to call Miss Slondo early the morning of July 5th for a ride to his vehicle, which then turned into 2.5 days of nightmarish beatings and injuries inflicted on Miss Londo by the defendant and his co-defendant in this case, all while there is a child present for most of these particular allegations. The people feel like Mr. Keene is a danger to the community. He does have some limited history, including past violations of protection orders, as noted by Ms. Londo. And for those reasons, I guess I'll just touch on the fact that this warrant has been outstanding for approximately 3 weeks. We are appreciative of the defendant turning himself in, but that is after a 12-day manhunt involving state authorities. I think it was in defendant's best interest to turn himself in, but the credit that he should get in terms of the amount of the bond should be limited, as it wasn't like a immediate surrender base once the warrant went active. So for those reasons and to protect Ms. Londo's safety, the people are asking for a $100,000 cash or surety bond in this case. Thank you.
Thank you.
We don't even see 100,000 on murder. And I think it's not enough for this guy. I think it should be triple that.
All right. Mr. Keene, given the nature of the allegations, your actions after the arrest warrant, and the relevant criminal history, you do have some criminal history of assault. I think it's appropriate for you to remain incarcerated until you can see Judge Maker. I'm going to set your bond at $75,000 cash or surety.
So she lowers it. He's going to meet his maker, guys. He'll meet his maker. Is it really him? He hasn't blinked. He hasn't moved. He hasn't reacted. Maybe it's not him. Maybe it's not him.
As a condition of that bond, I'm going to enter a mandatory protection order. I'm going to review the terms of that order with you and ask that you acknowledge them on the record. The protected party is Katie Londo, and it's ordered that you not harass, molest, intimidate, retaliate against, or tamper with any witness to or victim of the acts that you are charged with committing. You must vacate the home of the victim, stay away from the home of the victim, and stay away from any other location the victim is likely to be found. You shall refrain from contacting or directly or indirectly communicating with the victim. You shall not possess, purchase, or control a firearm or other weapon or any ammunition. You must relinquish any firearm or ammunition in your immediate possession or control within 24 hours of your release from custody. You must complete an affidavit and file it along with proof of relinquishment with the court within 7 business days. You shall not possess or consume alcoholic beverages or controlled substances. Do you understand the terms of that order, sir?
Yes, Your Honor.
It is him.
And please understand that violation of the protection order is punishable as a separate crime and as contempt of court. So it's important to abide by the terms of the protection order while it's in effect. We can set you to see Judge Maker on August 18th at 10 a.m. Does that work for you, Ms. Mayton?
No, Your Honor, I'd ask the court to set it to August 11 at 10.
August 11 at 10 a.m.?
Yes.
Does that work for you, Mr. Lund?
Not sure if Judge Maker has a docket on
Let me double check.
There is no docket for Judge Maker on August 11th. This is the clerk.
Okay, yeah, I think her next docket is August 18th.
It'll be August 18. I am in her courtroom on August 18th, but I do not know if there was one on the 11th. I know there is a docket on the.
That's
And
my
did you
dad's birthday.
say 11 a.m. or 10 a.m.?
I said 10 a.m.
Okay, great. Perfect.
All right, August 18th at 10 a.m., sir.
Thank you, Your Honor.
All right, thank you.
I don't know if I want to get that or not. I'm torn between getting that or not getting that.
All right, now we'll go back to Garfield County. Ms. Miller, who would you like to call next?
Judge, I can call Mr. Skylar Kemp next.
All right. This is 25M359. Hello, Mr. Kemp.
Good morning, Jill.
Morning. Afternoon. and
Judge, I
I
do waive advice of
Okay.
the charge here. I do recognize that the court saw Mr. Kemp, I believe it may have been yesterday or the day before, very recently. What I'll note is this allegation is an allegation that he violated the protection order. I'm sure the court has had the chance to review the affidavit, but just to reiterate the very, very minor nature of the allegation here, it's that he allegedly texted the alleged victim in the case that the court previously had Mr. Kemp on and told her she could get her belongings from his place. Notably, there's no indication from the affidavit that Mr. Kemp was there when she went to get her belongings. And I did speak to Mr. Kemp, and he advised that he understands at this point that even contact as benign as that.
Okay, I know, I want them to no contact when they get a no contact order. I want them to absolutely no contact. I really do. But I wonder how they found out that he texted her and said, you can come over and get your stuff now. I wonder how they found out, because if he texted her to say, you can come and get your stuff, and then she came and got her stuff when he wasn't there, like they just said, and then she reported him for that, what a bitch. He could have just kept her stuff until she figured it out a different way.
Is a full violation of a protection order. Mr. Kemp does contest the way that the allegations are laid out in the affidavit, but I think it's important that the court know that he fully comprehends the very serious nature of these protection orders, and he will not do anything else to further jeopardize himself. He advised he will not be in contact with the alleged victim any further, and it seems as though there's no reason for contact at this point, as she had the opportunity to get her belongings when she was at his dwelling for that, what she described as 2 hours in that affidavit. Mr. Kemp, as the court knows, does have criminal history. I'll note that Mr. Kemp, I have been representing him on a district court case, and he has been in good communication with me. I do believe we are very near to a resolution. So Mr. Kemp is someone who has demonstrated to me that he is going to take care of his cases and work towards resolving them. I'll further note that Mr. Kemp has assured me he will come back to court. I know that he has a phone because I have been in communication with him previously regarding his district court case. And I'll just again reiterate the relatively minor nature of the allegations here. We are asking that the court consider a personal recognizance bond on this particular case. I'm specifically asking that the court set that in the amount of $1,000 personal recognizance.
So, Tona, Cowlitz County, back in 2023, no one else was playing Cowlitz County on YouTube. They stream on YouTube, their YouTube courts, but no one else actually played them. I started playing them, and you would not believe the backlash I got, the comments I got. People really, really, really hate that county. I don't know why. I don't know why, but it's changed now because I see other people streaming Cowlitz County. But when I first started showing their cases, I would get these hate-filled comments about how horrible that court is, and they never want to watch that court again. And Lisa, you live in Washington. What the heck is going on in Cowlitz County? I don't even know. I wish I saved some of those comments. I delete most of the. If it's filled with hate, I delete the comment because this is no place for hate. But yeah, it was bad. It was like as soon as I put a short clip up for Cowlitz County, I got comment after comment after comment about that county.
I also recognize that there is a parole hold currently, but I understand that Whether or not parole will come and get him is up to them. And there's a possibility that that lapses. And if that's the case, Mr. Kemp would be able to get out on that personal recognizance bond. He does know that he has court coming up with me in district court, and he will be there for that. And I have every belief that he will appear with the court for any dates that are set.
Thank you. Mr. Lund?
Your Honor, the people are asking for a $2,500 cash or surety bond in Mr. Kemp's case today. As Ms. Miller noted, he was here recently on a domestic violence case involving the same victim, Ms. Flauger. He then goes and immediately violates the protection order. Mr. Kemp also has 9 prior felony convictions as well as 11 misdemeanor convictions. We appreciate Ms. Miller's record about him respecting the protection order, but he was clearly advised earlier this week and then just turns around and immediately violates that. As we know, with domestic violence offenders, typically things can escalate pretty quickly. And so for Ms. Flauger's sake,
I retract my prior statement. I retract it. He should not have done that. He deserves what he's getting right now.
we are asking for that $2,500 cash or surety bond today. Thank you.
Thank you.
Oh no! If
Well, I think
you
it's a relatively minor.
if you have a hate-filled comment and it gets deleted, that's not my fault. It's just not.
Alleged violation of the protection order. I did note that he wasn't there. I'm going to set a $1,000 personal recognizance bond in this case. I'm not going to enter another protection order, but Mr. Kemp, the protection order that I previously entered in the other case remains effective. So you do need to continue to abide by that protection order, okay?
Thank you so much.
Yeah, and that means no contact with her at all.
Message or nothing.
Did she get all of her belongings?
She got everything. I went to a meeting. with
Mr.
my
Kemp, I'm going
boss.
to encourage you not to talk right now.
Everything's
I just
good.
wanted to make sure
She's got all her stuff. Nothing's left at the house.
she doesn't need to go and get any more of her belongings from your home.
No, there's nothing there.
Okay. All right, then let's set a court date for you to appear in front of Judge Petotsky. Do we want to use the public defender date, Ms. Miller? August.
Yes, Judge, I think that makes sense. That's August 20th. Is the court still
Get
there?
out for a minute.
Oh, Judge, yes, we can use that August 20th public defender date.
I think we lost them. So,
Good.
Have internet, the record's still going.
Can you all still hear us?
we can hear you, we just can't see you, Your Honor.
I can hear the court and August 20th works.
Yeah.
Ms. Miller?
Yes, can the court hear me?
Her phone seems to have disappeared.
Everybody.
Oh, I see. Yeah, mine doesn't look like that.
Seems to be like that's directly, just still have internet. We just disconnected from everybody. Trying to see if we have internet since we're connected, but I keep connected. Oh no, we got it. There we go. Oh, I think it's coming back.
You kicked me out saying this says try again now.
It's starting to bring people back in.
Can the jail still hear me?
Yes.
I'm gonna
Oh, I can now. Hold on,
fast forward it.
We lost our WebEx for a minute. It's reboot. Judge Petotsky on this case, okay?
Thank you.
Take care. All right, and then shall we call Mr. Rowers?
Yes, Your Honor.
Patrick? Hello, sir. This is 25M285. Ms. Miller,
Judge,
what
I
would you
do
like
waive
to
it.
tell me on Mr. Rohr's behalf?
Yes, Judge, I do waive advisement of the charges. I think the court can see from the affidavit here that Mr. Rowers did, he has been very compliant with the DHS investigation, as well as law enforcement's investigation. Can the court not hear me? Can the jail hear me?
I can hear you. It looks like, court is muted.
Oh,
Did you file a proposed protective order in this case?
I did not, Your Honor.
Now I can hear her.
can the court hear me?
I can hear you. It looks like maybe we're
okay.
back up. All right, I'm so sorry about these technical difficulties. Ms. Miller, please go ahead.
Yes, Judge. So we are asking for a personal recognizance bond here. Mr. Rowers is, if the state is inclined to ask for one, he is willing to abide by any protection order that prevents him from having contact with his son. He has complied with the investigation from DHS as well as from law enforcement. Mr. Rowers does have criminal history. I believe the court can see that. But what I will note is that he is not on probation or parole currently. Mr. Rowers does live in Garfield County. This is his home. He is not planning to go anywhere. He does currently work at McDonald's. He's only been there for about 2 weeks. He really would like to keep that job. It's really important that he have that income in order to provide for himself, and when he is able to eventually be reunited with his son, to be able to provide for his son as well.
Monica, 6 bits. Thank you, thank you.
He was raised in Colorado, so he's a longtime resident. He left briefly for his time in the military, but then he came back and he has continued to live in the Valley since then. Right now, he does not have the ability to post bond. Unfortunately, his payday would be tomorrow. So far, he hasn't been in custody long enough to miss any of his work, but he would like to be able to keep it that way. His CPAT shows him as a category 2. Mr. Rowers,
Take my cats too, please. Does anybody know where Vail, Colorado is? I'm sorry, that's a stupid question. Does anybody know what county Vail, Colorado is in? Because I haven't looked, but I haven't seen any Vail, Colorado courtrooms. So they must be part of a bigger county.
very clear that he will absolutely come back to court and take care of his case. I do not have concerns on that front. He does wish to get out so he can continue paying his rent. He also recognizes that he has to, if the court does put a protection order in place, stay away from his son.
I haven't seen it.
He has agreed to do that. Right now, his son lives with his mother, so my client's mother, who is currently his legal guardian. He recognizes that he's going to have to stay away from that residence for the time being if the court does put that protection order in place. Ultimately, I'm asking the court to issue a personal recognizance bond and allow Mr. Rowers to return to court on his own promise to do so.
Thank you. Mr. Lund?
The people have no objection to a personal recognizance bond, and as the court noted, as this appearance was starting, the people did not file a protection order in this case for the child. That is based on Miss Martin's record, who I believe is in the courtroom here behind me today. They are working with DHS, and the defendant's mother had custody of the child even prior to this case. They are working on establishing a supervised visit safety plan kind of arrangement. And so instead of interfering with that process by filing a protection order and maybe interfering with the defendant's residence, the people elected not to do that in this case. Ultimately, we're comfortable with the defendant receiving a PR bond today and believe he will return to court. Thank you.
Thank you. All right, Mr. Rowers. I'm happy to release you on a $1,000 personal recognizance bond in this case. I'm not going to enter a protection order. Sounds like you're already working with the Department of Human Services and doing what you need to do to repair your relationship with your son. I don't want to interfere with that either. But you do need to return to court to answer for these charges, if charges are filed. And that will be in front of Judge Petotsky and Rifle. he has court on Mondays and Wednesdays in the morning. Do you have a preference for Mondays or Wednesdays?
Anytime in the morning would be fine, Your Honor. I work night shifts.
Okay. How about, we just go out a couple of weeks, do you think?
Kelly,
people
thank you for the
maybe
bits.
August
Thank you, thank
20th.
you.
25th.
The 20th is public defender, but the 25th is available.
Let's do that.
August 25th at 8.
And I try. I do try. I like every like 3 or 4 weeks. I try to get Australia and New Zealand, whatever I can get. I hope that I could find something, but man, I can't play it. No one would watch it with me.
30, sir? Will that work?
I can make that work.
All right. And if you do wish to see if you qualify for the public defender, you can file an application with their office. If you do qualify, they can maybe change your date to a public defender date, but you'll need to file the application and qualify first, okay?
Yes, Your Honor.
Okay, thank you. Good luck to you.
Thank you.
Okay, we're going to go to Lacey State now. I haven't seen this yet because it took me forever to edit it so that you guys could even hear it. I'm looking. I'm really looking. No, 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 no. Shh. I just played it earlier, so it's here. It was, oh, I remember. This one.
The cash alternative would be fine.
Okay, essentially total $1,000 bond, $100
Correct,
cash.
yes, yeah.
I need to know if you can hear this because this audio is so bad that first it's mono, so it only comes into one side. So if I would have played it as it was, only half of you would have been able to hear anything at all, even as bad as it is. So I had to fill the right with the left and bump it up. But I don't know if it doesn't always work. So if you can't hear it, let me know and I'll go back to Colorado.
I guess that's true, yeah.
Okay, Mr. Lockhart, does defense wish to be heard?
And Your Honor, we're just asking for a PR release today. Mr. Lorenz does not have any ability to post bail. He's never been employed, so he is not on Social Security. He's only on the temporary, effectively with EBT at this time. So has no ability to post bail, and we're just asking for that PR release. But we would ask to be appointed on this matter to give him an extra set of contacts.
All right, let me take a quick look then. So we have that sentencing out of Linden. That actually had a pretty substantial bail on it. Now we have theft was set at $1,000. That was the warrant. So this would really be a reduction from there. Lots of warrant history. All right, one last thing. Just checking how long the warrant was outstanding on the theft. Looks like it's May of last year, so over a year ago.
I really
think
like
the
this
city's
judge.
request is probably reasonable given how long that warrant was outstanding and the overall warrant history. So the court will find there is some risk of flight, but I'm going to go ahead and I'll reduce the bail amount on the theft from $1,000 to $500. It's going to be bondable. $50 cash alternative is fine, and then it'll be $250 per charge on the obstructing and resisting. That's bondable as well with a $25 cash alternative. So the total at this point will be $1,000 bond, $100 cash. And Mr. Locker, you indicated you don't believe Mr. Lorenz can post that.
No, Your Honor.
Okay, well, I'll have to go ahead and find him eligible for the public defender then, since he won't be able to apply. All right, standard conditions then, Mr. Lorenz, just appear timely for court, have no new criminal law violations while the case is pending. I'm going to set 2 court dates for you. One will be in custody, one will be out. Mr. Anderson, based on, do you want to go longer or shorter than 2 weeks? Since 2 weeks would be a Friday.
2 weeks is fine.
Okay. I guess I'll do Wednesday. Monday, 25th at 8:30. And then, Madam Clerk, what's our out of custody date? 9/23. Okay, perfect. September 23rd. At 1:30 in the afternoon. So that's what we've got here. Mr. Lorenz, do you have any questions, sir, about any of that?
No.
All right. I've gone ahead and signed off on that. Thank you, Mr. Lorenz, for your time. All right, counsel, is anything else ready to go on your end?
Yes, Your Honor, we can call the matter of Joy McGuire.
All right, Joy McGuire. Cause numbers 5A034939, 5A06903999, and it looks like a restitution review on 4A05797733. Morning, Ms. McGuire.
Good morning, how are you?
I'm okay. Thank you, ma'am. We're going to take a quick look here. So on one of the arraignments, I did review the probable cause this morning. I think the other one, yeah, was a returned warrant. So let's go ahead then and start with the arraignments, counsel. PC has been established on the 329. I will find it's established on the 399 unless you have any comments there.
No, Your Honor.
All right, probable cause is established on both of these. And Mr. Anderson, it looks like the city also has a motion on this, or perhaps that's the court's motion to merge history.
Yeah, I think you just need to merge the histories.
All right, Mr. Lockhart, I see you already signed off, so any objection there?
No, it makes sense, just to correct the spelling.
All right, I'll go ahead. Granting that motion. So, Ms. McGuire, this is just a motion essentially to make sure that all of your history is linked together in the database here. Pretty straightforward. So, okay, starting with the arraignments then, Mr. Lockhart, you did say you're prepared to waive a formal reading?
Yes, Your Honor, and we'd ask to waive a formal reading of rights, and we'll just ask to enter a not guilty plea on each of these two cases.
Thank you. All right, court will go ahead and waive that formal reading. Ms. McGuire, I am entering not guilty pleas on your behalf to both of these.
Thank you.
Mr. Anderson, would you like to address conditions?
Yes, Your Honor. The defendant obviously was, I think, out on one, I think was a warrant that was issued back in earlier July. I think it was issued as priority hold.
It was,
And obviously the newest one is why she's here today. The city's asking for bail on each for a total of $2,000 cash performance, so $1,000 on each of the two charges. Otherwise standard release conditions, and to abide by the anti-harassment order, which is already in place. The court is probably familiar with Ms. McGuire by this point, but just in case you're not, the priors include 2 convictions for harassment in 2025 earlier this year. Prior history, including malicious mischief from last year. Pending cases as well, looks like still pending in Berg 1, Rob 1, Theft 2 in Superior Court. So given that history, I do think, and the failure to appear on the prior case, plus, again, the reason we're here is because she was arrested for a new violation of that, alleged violation of that order. I do think the $2,000 total between the two charges is frankly probably light, but it is appropriate under the circumstances. And again, I'll reiterate $1,000 cash performance on each is the city's request.
Thank you, Mr. Anderson. I guess because I can't see the linked history, you said there's a Berg 1, Rob 1 in Superior Court pending.
The notes made by the prosecutor says, yes, they were pending. It's still from this year is a Berg 1, Rob 1, Theft 2.
Got it. Okay, thank you. Mr. Lockhart, would defense like to be heard?
Yes, Your Honor. We've just asked the court to take into consideration just that Ms. McGuire is not in a position to be able to post any amount of bail. We do represent her on the those post-conviction matters on the 4A case number. We would ask to be appointed on the new case matters at this point. We would be asking for a PR today just based on that inability to post any amount of bail. She also has a number of animals she does take care of. Unfortunately, she's the only one to take care of those animals. So we would be asking to PR based on that, as well as ask for pretrial monitoring by the behavioral health unit in lieu of any amount of bail. And then I think with both probation as well as with an attorney on board, I think she would be able to appear for court and, hopefully stay in line with the no contact orders.
Thank you.
Yes.
Does the city have any position on pretrial supervision?
That's not the city's request.
All right. Okay. All right. Actually, I can see both histories. It just depends on which case I'm looking at. So, okay. So I do see we've got those pending. Berg 1, Rob 1 out of Superior Court, pretty serious there. Looks like pending malicious mischief, first degree out of Superior Court, 2 prior harassment convictions. It's a lot of pretty serious history, actually. Court's going to find, I think there is clearly some risk of a violent offense being committed. there is a risk of Ms. McGuire interfering with the administration of justice. And really, based on the fact this was already in warrant status and there were other warrants, the court would find that there is a flight risk as well. So, all things considered, I'm going to grant the city's request here. $1,000 on each, 10 times bondable will be fine. That's going to be the court's order. With that bail being imposed, Mr. Lockhart, I guess I'll also just confirm you don't believe Ms. McGuire is going to be able to post that?
No, Your Honor.
Okay, I'm going to go ahead and I'll find her eligible for the public defender then, since again, she won't be able to apply.
What about my dog? That's a dog.
Ms. McGuire, I am not entirely sure I have a good answer for you in regard to that. Hopefully there's someone you can reach out to. Perhaps counsel can help you reach out to someone, but unfortunately the bail is going to have to be posted one way or another. The conditions here are going to be pretty straightforward. Just appear timely for court, don't pick up any new criminal law violations, and most importantly, make sure that you abide by any active no contact or anti-harassment orders. Subsequent violations, obviously, it's only going to get worse from here. And Mr. Anderson, you were just requesting pretty much standard conditions.
Yes, Your Honor. And abide by the anti-harassment.
All right. So I'm going to have to set 2 court dates here. One will be in custody, one will be out. The in custody date, I guess we'll go to that August 25th date again. That's a Monday, the 25th at 8:30. And then out of custody, 9/23.
Sorry, what was the in custody date? I'm sorry.
8/25.
8/25, thank you.
Thank you. And then I think that's actually everything because we're not entering new orders here today. So, okay. All right. And then we do need to address the restitution. I see that there was a restitution review on the 4A cause number, and we actually have a new restitution order uploaded. So I guess I'll hear from the city first. Mr. Anderson, are you requesting a new restitution order there?
Yes, I think it was set for a restitution hearing, restitution to be determined. The restitution is determined by the city is to be $928. There was an invoice here for that amount. So we were asking the court to set it in that amount.
Got it. Okay. All right, Mr. Lockhart, would defense like to be heard on that?
No, Your Honor, it's a significant reduction from what I think he was originally asking for. And it seems more in line with kind of the nature of the damages as well. So there's no objection to that.
Okay. Sounds like everyone's in agreement. Makes sense. So I'll enter the restitution order, $928. Set the payments as low as I can go, $10 per month based on the financial information provided here by counsel. And then I'll set the first payment out. I guess I'll go about 3 months. And if Ms. McGuire is still in custody, obviously we can address that. But right now, we'll say November 10th, first payment due. And Ms. McGuire, once you are out of custody, you're going to need to contact Signal Management in regard to those restitution payments. They're the third-party vendor our court uses to collect payments, and all of their information is on the judgment, or rather on the restitution order that you will get a copy of.
Thank you.
Thank you. All right, I'll sign off on that as well, and I think that does cover everything on our end. So, thank you, Ms. McGuire.
Thank you.
All right, Your Honor, I'm going to pass it off to Mr. Lukoff for the Frederick Robertson matter.
Sure. All right, Frederick Robinson, excuse me. Cause number 580738283. Morning, Mr. Lukoff.
Good morning, Your Honor. I'm here with Mr. Robinson. He's coming forward. Preliminarily, I went through the advice of rights with him, and he read that. We discussed it, and he signed it.
Very good.
And Your Honor, the city is not moving forward with this case. I'm uploading apparently a dismissal. The alleged victim does not wish to proceed. The city is not going to pursue this charge.
Okay, very good. Well,
Your Honor, no objection.
Thank you, Mr. Lukoff. Mr. Robinson, good morning, sir.
Case dismissed.
So at this point, then, I'll grant the city's motion. The charge of harassment is dismissed without prejudice. And I'll sign off on that very shortly, Mr. Robinson. City attorney's just finishing up the order there. So what that means, sir, is that A, this case will not be proceeding, and B, you should be released today within the next couple of hours. I know the jail takes a little bit of time to process the release, but you'll get out, I suspect, this morning.
Easy enough.
Yeah, and then just sign it.
Thank you. Thank you very much, Mr. Robinson. All right.
Thank you, Your Honor. That's all I had. May I be excused?
Absolutely. Thanks, Mr. Lukoff. Have a good weekend.
Bye-bye. Easy peasy.
All right, there we go. Thank you, Mr. Anderson.
Yep, thank you.
All right, anything else ready, Mr. Lockhart?
Yes, Your Honor. I call the matter of Ryan Scott.
All right, Ryan Scott, cause number 5A07244439. It's on for an arraignment here today. Morning, Mr. Scott.
Good morning.
All right, counsel, I did review probable cause. Does defense wish to be heard at all?
No, Your Honor. I reviewed that earlier.
All right, court does find probable cause is established for the charge. It's the one count of driving under the influence. Are you prepared on arraignment this morning, counsel?
Yes, Your Honor. At this time, I'd waive a formal reading of rights. We did go over those. Waive a formal reading of the probable cause and enter a not guilty plea on his behalf.
Thank you. All right, Mr. Scott, I'm going to go ahead and waive any further reading of your rights in the charge. Sounds like you've reviewed that with counsel already. I'm going to go ahead and enter a not guilty plea on your behalf that does preserve your rights and defenses in regard to the charge. Would the city like to be heard?
The city's fine with a PR release today with standard release conditions. According to the notes here, defendant does not have any other history.
Very good. Thank you, counsel. Mr. Lockhart, any objection by defense?
No objection. We would just be asking for an exception. Mr. Scott does go into establishments that sell alcohol for work. We would just ask that, once he finishes up his business there, he'll be able to leave.
City, no objection to that. That makes sense.
Okay. Can you just tell me so I can get the order specific here? What is the nature of the work?
I do photography and videography for musicians and stuff. And so sometimes I'll go to venues where they have bars.
Got it. Okay. All right. All right. Well, let's go ahead and go through everything. That shouldn't be a problem. Mr. Scott, you'll be released on your personal recognizance here today. I've looked at your criminal history. I don't see there's anything at all. So given that,
this is
release is obviously perfectly acceptable at this point. Standard conditions on a DUI: simply appear timely for court. Don't pick up any new criminal law violations. Don't drive without a valid license and proof of insurance. Have no drug or alcohol related infractions. Do not use or possess alcohol, non-prescribed drugs, or cannabis. And don't enter, well, there's going to be a caveat here, but generally speaking, don't enter any establishment whose primary business is the selling or serving of alcoholic beverages or cannabis. And I'm going to write in here, the exception to that is obviously for employment purposes. For work, you can. But if it's not for work, then you're not allowed to.
Understood.
All right, so I just wrote on here, defendant may enter establishments serving intoxicants for employment-related purposes only. It shall not possess or consume any intoxicants and shall leave the premises immediately upon completion of any work-related activities. So I think that covers it. Do you have any questions, Mr. Scott, about any of those conditions?
No.
All right, you're going to have to screen for the public defender once you're released from custody. Of course, you're always free to hire your own attorney if you wish to. But I'll give you the link for the public defender. Once you are released, you just need to go online and apply if that's what you'd like to do. And if you do qualify, we'll get you an attorney assigned. Next court date is going to be a pretrial hearing here at the Bellingham Municipal Court. That will be on September 23rd at 1:30 in the afternoon, and that's a Tuesday.
Okay.
That's going to be on this order as well. All right, I'm signing off on this. Mr. Scott, thank you, sir. Do you have any other questions for me?
No, thank you so much.
Appreciate it. All right, thank you.
So I would recommend these two guys here, so we can see the Jolly or Lisa Roy.
Are they DUI specific?
Yeah. Yes.
Thank you so much.
No problem. Yeah.
All right, who else is ready, counsel?
Your Honor, I can call the next matter of Jeremy Hills.
Hills. Okay, there we go. Jeremy Hills. Morning, Mr. Hills.
Good morning.
Cause number CB0107053, CB0104074, and 580624974. I believe that's a warrant return. I believe they're all actually warrant returns. So let's go ahead and start with the arraignment counsel. Probable cause was established on that when the warrant went out. Are you prepared to proceed there?
Yes, Your Honor. At this time, I would ask to waive a formal reading of rights and just enter the not guilty plea on his behalf.
Thank you. All right, Mr. Hills, I'll go ahead and waive any further reading then. Not guilty plea is entered on your behalf on that new charge. That's the hit and run attended. That does preserve your rights and defenses in regard to that. Would the city like to be heard?
Your Honor, a couple of these cases at least are quite old. The driving third in 2020 and driving third in 2019. Defendant had shown up to court previously, so they are pre-trial stage, so he was very much aware of his pre-trial dates. The defendant has pretty horrible driving history, even going back to 2020. At least at that point, he already had 17 prior driving thirds, and then we have a subsequent hit and run, more recent, which he also failed to appear for. Given that, the city is asking to maintain bail on all three cases, given his extensive driving history and fails to appear. In the hit and run attended case, he does have a prior hit and run unattended. I realize it's from a number of years ago, but given his terrible driving history, I'd also ask that he surrender plates to any vehicles in his name to probation if he is released. But otherwise, I do believe bail would be appropriate on all cases, given his warrant history and extensive criminal history that is related.
Thank you. The hit and run was issued as a cash amount. Is that the city's preference?
What is the cash amount that's issued?
It was issued at $1,000.
Yeah. The city's fine with I guess the court changing that to a appearance bond.
Okay, thank you. Mr. Lockhart, would defense like to be heard?
And Your Honor, I can just let the court know that Mr. Hills is currently unemployed. He is going to be, it sounds like if the court's going to impose bail, we would be asking to be appointed on these matters. He does not have an ability to post any amount of bail. And we would be just asking for the PR release today. I think with the attorney on board, I think he would be able to make his court appointances, just have that extra set of contacts to make, and hopefully be able to move these cases forward.
And work. Well, Mr. Hills, if these cases weren't so old, I would be releasing you under personal recognizance, but one of these is from 2019 and one of them is from 2020. 5-6-year-old cases, you've had a number of opportunities to appear and address these, and you simply haven't. So the court is going to make a finding that there is a risk of flight given the age of these warrants. I'm not confident Mr. Hills will appear for court on his own volition. So the bail amounts on the driving suspendeds, those were set at $1,000 bond. Those will just be maintained. It sounds like there's no strong objection from the city to making the hit and run bondable as well. So I'll go ahead and do that. So the total here will be a $3,000 bond or $300 cash to assure Mr. Hill's appearance in court, based purely on the warrant history and the length of time these cases have been outstanding. Mr. Lockhart, you don't believe Mr. Hills is going to be able to post the bondable or the cash alternative amount?
I don't believe so, Your Honor.
All right, Mr. Hills, I will find you eligible for the public defender then, since you're not going to be able to apply for one. We'll get you an attorney assigned. The conditions here will be pretty standard. Just show up to court on time, have no new criminal law violations, and don't drive without a valid license, proof of insurance. We'll set 2 court dates. One will be in custody, one will be out. The in custody date, let's do Wednesday, August 20th at 8:30. And then the out of custody date will be September 23rd at 1:30 in the afternoon. In regard to the last request here, I'm going to grant the city's request to surrender plates. The overall history I'm looking at is very, very poor in regard to driving. So, Mr. Hills, if you were to post the bail or bond, which I do understand is not likely based on what counsel said, you would need to do one additional thing. You'll need to report immediately to the Whatcom County District Court Probation Department, surrender plates to them, and then that pretrial supervision will terminate. That's the only thing that I'm having you report to them for. There's no testing, there's no anything else. You just need to go report to probation, surrender your plates. They are located on the 4th floor of the county courthouse. It's the building right next to the jail. You know what I'm talking about, sir?
Yeah.
Okay. All right. Once you do that, you will not have to report to the probation department anymore on a pretrial basis. Okay, there we go. I'm going to go ahead and sign off on that. Mr. Hill, do you have any other questions, sir, about anything that we just discussed here today?
No.
All right, thank you very much, sir.
All righty, we did it. Wow, muting that white noise makes a huge difference, doesn't it? It like pulls you back to reality a little bit. There, I slowed it down for you. I slowly took you out of the white noise. I don't know why he reminds me of Judge Van. I don't know why, but he does. Every time I see him, Judge Van flicks across my brain. He doesn't have someone, to interact with like Judge Van does with his bailiff. But you're welcome, Monica. Thank you, Monica. Oh, I want to make sure I get this right. I forgot. When I start my live stream, everything leaves my head, and I can't remember everything. MJD, thank you so much for the PayPal of, I think it was 111, even though it says 107. Over 100. I appreciate it. It was on August 10th. So it's been 3 days, and I kept forgetting during the middle of my lives, but I really appreciate it. That came in at a good, that you hit at the right time. Let me tell you. I mean, thank you. I really, really appreciate it. I really do. Thanks. All right, we're gonna go to OJ. I hope the rest of you have a great day. Bye, guys. Thank you.
Got these life echoes, digital dreams. Through the screen, her blue eyes gleam. Wicked humor, sharp as a knife. Her stream sparks electric light. Late night when the world sleeps, she's the friend that always keeps. Giggles roll like thunder loud. She stands out in any crowd. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted sharp. In a way, there's no alarm. Freedom tales late into the night. Her laughter feels just right. Even when my world turns gray, with a giggle, she lights the way. Her eyes hear a sky so blue. In her jokes, there's a truth so true. With each string, she brings the light. Turns dark days into bright. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted sharp. In a way, there's no alarm. Streaming tales late into the night. Her laughter feels just right. Even when my world turns gray, with a giggle, she lights the way. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted sharp. In a way, there's no